going as soon as possible. So good afternoon, everyone. I'm Liz Rosser. I'm Executive Director of Resources at the SRA. I hope you've had a good lunch and enjoyed the sessions you've attended over lunch. Very pleased to welcome you to this session on our new accounts rules, your questions answered, or at least as many of them as we can answer in the time, because we certainly had a lot of questions when we ran this session this morning. So we'll press on and try and get through as many questions as possible. So with that in mind, I'd like to move on and introduce my two colleagues. So on your right is Jatinderpal, Policy Associate at the SRA, and on your left is Sean Hankin, Head of Forensic Investigations and Intelligence at the SRA. So Sean and Jatinder have got a wealth of knowledge and experience in this area. In fact, they authored the accounts rules, so they really do know everything there is to know, and you're in very safe hands with your questions later. So they're going to talk for about 25 minutes so that we've got plenty of time to help you with your questions afterwards. So without any further ado, I'll ask Jatinder to come and start things off. Thank you.
Thank you for that, Liz. Yeah, rather optimistic to say that we know everything about the accounts rules, but yeah, let's just hope that we can do you justice today. Just to put a bit of context, because I think from this morning it became apparent that the accounts rules are key for everybody. Just from the last count that I had pulled from our business intelligence team, there was just over 7,000 law firms that had confirmed to us that they hold or receive client money, so in some shape or form. So it is a huge population that hold client money and need to understand the risks that are associated with that. We're going to give you an overview in terms of what's happening with the accounts rules, how they've changed, what we've been doing to support you get ready for the 25th of November. And as I said, we'll take your questions at the end as well. So the accounts rules, where are we now? We've got clearer, sharper rules, taken out a lot of the prescription, a lot of the guidance notes that sit under the current rules, but also reduced the number of rules as well. It's not to say that just by reducing the rules that they're less important. I think what we've now got is a really, really good framework, a principle-based framework in terms of what we expect law firms to do in terms of complying and making sure that client money is kept safe. There's reduced prescription, so again, we're allowing you to exercise your professional judgment so that you're not tripped up by what we have at the moment, technical or prescriptive rules that can be breached just because of the nature of the way they've been written. We have a definition of client money following our consultation, and we've clarified our approach, or should we say codified our approach in terms of firms that are using a third-party managed account. We'll touch on the requirement to complete checks and keep good records as well as we go through. Again, there should be no surprises there. It's more about making sure that, yeah, what you're doing is in accordance with what we expect of you. And then the new approach to final reports, which is at the moment law firms, and we at the SRA refer to as cease to hold reports. So the obligation doesn't actually sit in the accounts rules. The obligation sits in the Code of Conduct for Individual Solicitors, RELs or RUFLs, which is that if you are holding or receiving client money, the obligation is that you must safeguard money that's been entrusted to you. Some people say that, we can't find the rule in the accounts rules that says you need to keep client money safe. That's because the accounts rules are the mechanism for how you keep client money safe or what we expect of you, but the obligation sits in conduct. And I think that's where we're saying that have you considered your obligations in conduct, because as an individual, it's more important now that you understand the obligations that the new accounts rules bring. And in order to sort of assess whether or not you're keeping client money safe post 25th of November, what we're expecting firms to do is making sure that they're managing the movement of money promptly. At the moment, we've got, should we say, rather prescriptive rules around how quickly you need to move money. So we've got the 48-day rule if you received client money into your business account, or we have the 14-day rule if you receive office money or it sits in your client account that it needs to be moved out within 14 days. What we're now saying is that you need to move that money promptly. What promptly means for you is going to be different for what it means for me, what it means for Sean and Liz. It's up to you to assess and look at who you're dealing with in terms of your clients and the nature of the matter that you're involved in terms of how quickly that money needs to be moved. I gave an example this morning of if you were dealing with a client in a clinical negligence matter, that what you might have is that the client needs access to their settlement monies immediately so that they can put into place care plans and anything else that they need to support themselves. Law firms shouldn't be relying on the 48-day rule in those circumstances. You should expect money to be moved swiftly, I'd say immediately, once it's been received to the client so that they can do something with it. There's other transactions as well that are just as important. So again, in a conveyancing transaction, it's important that you move money as soon as you know that the other side are ready to receive. It's about exercising your own professional judgment, and I think this is important to stress as well, that what we don't want law firms to be doing is saying that, okay, we've seen this, or someone's told us that we can do this, and we think we're okay. It's more about what are you doing? What's your firm doing, and what are the people that are handling or receiving client money in your firm doing? It's only then that you can develop effective systems and controls, and I think this is, a point that Juliet picked up on this morning, or it might have been Paul even, that said that when we launched 2011, it became a culture of compliance, whereas now this is about protecting clients and upholding professional standards. And how you do that is up to you. So in terms of the effectiveness of systems and controls, this is up to you to test. I'm quite conscious that there are a number of providers out there that are providing compliance advice or risk assessment tools to you, but at the moment it seems that it's a very tick box exercise rather than a proper assessment of whether or not you are keeping client money safe. And I think following on from that, it's important to stress that you as a firm, if you're the manager or owner of a firm or a principal in a firm, that you speak to every member of staff in your firm. It's not just about the AML obligations that kick in when you do receive money, but just generally speaking, that if money was received at the firm by the receptionist, that they should know what to do with it, i.e. move it into the cash office and say, hi, can this be promptly banked and ledgers updated accordingly? So the revised definition of client money, this is something that we consulted on in 2017 as part of the consultation. What we consulted on isn't where we've ended up. We've actually listened to what people said to us, so I'm sure you'll be pleased to hear that the SRA do listen. We did have a definition which would have meant that if you were receiving money for fees and disbursements, you would have had to move that money into your business account. We listened, and we've now introduced, which is a second point, an exemption, that if the only money you receive is money for your fees and disbursements that you're liable for, you don't have to place that into the law firm's client account. It can be held outside. But this is a business decision. It's not a case-by-case assessment, so it can't be that you do it for one client and not the other. It has to be a business model that you operate. But as is now, if you do receive transactional money on behalf of a client, you can't rely on the exemption. You would have to just keep money in the client account as you do now. There is guidance that was published in the form of Q&As, and I think it's quite helpful in the sense that it provides those that are moving into the regulated space for the first time to understand their obligations, but also for those that are moving into the exemption in terms of what they need to be telling their clients. Even though it's an exemption and provides opportunity for firms, opportunity always brings risk. And if money is now sitting in the firm's business account, there is a risk that, if the firm was subject to insolvency proceedings, that money could be eaten up by creditors. So it's important that as part of the negotiation, or should we say engagement that you have with your client, that you tell them that, I am only holding money for my fees and my disbursements. And it is defined as client money, but there is a risk associated with it. If the client doesn't accept that risk, then it might be that you have to think about alternatives, or they might decide to go somewhere else. In terms of keeping client money safe, like I said, that this has been set out and made quite clear in the Code for Conduct for individuals, that this is an obligation in conduct. And what we're saying is that all client money must be kept separate from the firm's money, and that's not different to what you have now. It's quite clear. It's set out in primary legislation that client money has to be kept safe, and the rules that we then write have to make sure that that's happening. But what we have now, though, is that the receipt of mixed money, like I said, doesn't have to be moved within the prescriptive timetables that we have. It needs to be moved promptly. Like I said, what's promptly for you isn't going to be what's promptly for me. So it's important that you understand as a business how quickly you need to move what is deemed to be your money into your business account. I think when I go out to speak, I always try and bring in that the accounts rules should not be read in isolation. They need to be read in conjunction with the Code for Conduct for individuals, but here, the Code of Conduct for firms. There's an obligation on firms to make sure that they're monitoring their financial viability, and as soon as they see a risk to their financial viability, that they plan for an orderly wind down. And I think this is important here, that if you are not moving your business money into your business account promptly, and there's a suggestion that the only reason that you're doing that is to stay afloat so you can survive on the interest that that account earns, there might be concerns that you're not financially viable as a firm. So again, it's more of a point to take away from today, that this is something that you do need to look at very carefully. Keeping client money safe, I think Juliet did mention this morning, that as soon as there is no need for you to hold on to client money, it should be returned to the client with a third party for which it's held promptly. Or immediately, I would say. I know that the rules say promptly, but as soon as you start holding on to money where there is no need, you bring yourself into the risk of operating your client account then as a banking facility, and I think that's where some of the concerns have come out before. It's important that you speak to your teams as well so that they understand that, that sometimes we hear that, oh, I was working on pre-completion work, I had nothing to do with post-completion work in a conveyancing transaction. So there's no communication between one team and the other, and no one knows who's responsible for the movement of money or repayment of the money back to the client. And like I said, that further moving on from that, client money can only be used to cover your costs after sending a bill or notification of costs that have been incurred. This is a slight change to where we are at the moment. The current rules, there's a concept of agreed fees where you can say to the client that, this is how much it's going to cost you, and we can take this money regardless of whether or not the matter completes into our business account. This is where we've now dropped the concept of agreed fees, because there is confusion between what is an agreed fee and fixed fees, and people think that fixed fees are agreed fees and vice versa. This is about making sure that there is still flexibility in the rules, but providing clients with that protection that they need. So any money that's received on payment of account of your costs can only be moved once the bill's been delivered. And in terms of disbursements, I think we've seen recent decisions, especially after the Slade case, where there's some disparity around, okay, when can the client challenge my bill? Is it when they issue an interim bill, or is it the final bill? And I think firms will really need to try and understand what this means for them. I know that Sean and I have been asked on a number of occasions in terms of what does this mean, because you've got a rule which says that client money includes money for unpaid disbursements, and then can we take that money once we've billed? And I think it's something that we might have to provide some sort of guidance on. But I think firms that are operating as they are now should be fine. It's more those firms that operate under the agreed fee model will really need to think about how they move forward. Other key risks, I've already touched on the first one, the concept of banking facilities. This is something that I was involved in last year in terms of updating the warning notice and setting out some of the case studies. Sean and I have seen a number of cases, Sean probably in the cases that have come through to forensic investigations and me through my engagement, is that more and more law firms are moving into the space where, yes, their client account is being used as a banking facility. So despite the warning notice that was issued, and then, like I said, updated last year with the warning note, with the case studies, we're still seeing this as a huge concern for us. We often get asked as well that, can you define a banking facility? And I think it's sort of one of those questions where you think, have I just really been asked that? And you just think that, a banking facility is where you are, providing banking facilities to a client. If it doesn't relate to the legal services or regulated services for which you're providing, then it's got nothing to do with you or the client or the firm. So be mindful of the risks, and that isn't moving away going forward either. The current 14.5 stays, has become tighter, like I said, because it talks about the regulated services, so the money has to be in relation to your regulated services. I suppose another risk that we're seeing an increase in, and this is something that we're receiving input from the insurers that are providing you with professional indemnity insurance, is that law firms are now more prone to cyber attacks or loss of money through cyber attacks. We've seen some really unfortunate cases where individuals have been subject to a cyber attack. And when I say it's sort of sad to see that, but in certain cases we've just seen, I can say in this room, complete and utter stupidity. And I think that's where the people like the tribunal have said that, okay, we probably can't prove dishonesty here, but what we can say is that the solicitor or the individual was so reckless that they should have saw that, that there was some red flags after, should we say, contact number 1 or even contact number 2, that this wasn't right. That if you're being asked to send round some transfers 1 time, 2 times, 3 times, there should be somebody, on your shoulder saying, this doesn't feel right. And that's where, in one case, the insurers declined cover on the basis that they said that, even though the individual was probably so reckless, it did border dishonesty because, they just carried on doing what they were asked to do by the attackers. So I think it's key that we have to ask law firms to make sure that, where you are keeping, or should we say holding or receiving client money, that you are managing risks associated with a cyber attack and what that means for you in terms of your professional indemnity insurance as well. I think with the new AML regs that are coming out in January as well, and I think there's already been some guidance as well, I think law firms are also going to have to think about what it means in terms of operating or using a suspense account. I think in our guidance we say that, that it's not an issue as such, but if you're doing something within 5 days of receiving that money, it's gone back to the source or you've allocated it to the right client ledger, then that would suggest that you're demonstrating good practice. Anything up to 30 days is probably acceptable, but anything beyond that is probably not acceptable in our view. Discussions that we've had with the AML team is that, even anything up to 5 or 30 days could be seen as not acceptable from an AML perspective. So there is something there that law firms do really need to consider about. Do you need to make a DSARS on the basis that you've had, a suspicious activity report on the basis that you've received money, but you don't know who it belongs to or where it's come from? Withdrawals, again, this isn't nothing new. Law firms should be familiar with this, but for those that are entering the space for the first time, it's just important to reiterate that withdrawals can only be made for the purpose for which the money is being held or on client's instructions. I think even on client's instructions, with the increase in terms of the AML obligations that are coming through, you are at risk of facilitating money laundering. So again, be mindful of what your clients are asking you to do. Linked to that, then, it's important that law firms do have effective systems and controls, and you can only do that if you've got the right people doing the right job. It's pointless saying that we've got a practice manager or that we've got a cashier or that we've got a coffer, but they've not got any interaction with the movement of money in the firm. So it's making sure, like I said, through the new rules, that we emphasise that client money should be withdrawn where it's appropriately supervised and appropriately authorised. That doesn't mean that the buck rests with the coffer. It could be with whoever's dealing with the transaction at that point in time. Balances under 500, or should we say residual client balances, it's still a key concern for us. A number of reports that come into the organisation are because law firms aren't managing residual client balances. But firms have said to us, where is this in the new rules? They can't see anything which says that they can withdraw client money under 500 and pay it to a charity or make an application to our ethics team. That's because we've now taken this out and said that you can only do it in prescribed circumstances. This gives us the flexibility then to manage the risk. If we think that law firms aren't managing the risk properly, we can reduce that 500 back to 50 as it was, or even 0, and every application has to come to the SRA. But we have confirmed, we issued our prescribed statement just a few weeks ago, which reiterates the current rule 20.2 in terms of what you need to do. Important to remember, or should we say take away from today, is that those prescribed statements are not guidance. They are prescribed statements. They should be treated and seen as any other rule. If we see that a firm has diverted from those prescribed terms that have been set out, we will enforce them just as we enforce any other breach of the rules. In terms of balances over 500, they should be treated as is now, and a firm has to make an application to our ethics team. Systems and controls, again, it's just reiterating what we've already got at the moment, but re-emphasising the importance that good compliance can only happen if you have got good systems and controls in place, and that includes making sure that your records are accurate, up-to-date and chronological. Your reporting accountants will be there asking you to provide records and other information to ensure compliance, not just with the rules, but to establish whether or not there has been a risk to client money. Linked to that, then, we are asking law firms to make sure that they keep ledgers, obtain statements at least every 5 weeks and carry out their 5 weekly reconciliations. In terms of safeguarding client money, so again, what we've said is that, if you're operating or signatory to a joint account, there are requirements that are in place. And in terms of where you're signatory to a client's own account, this is where you've been appointed as deputy through the Court of Protection or as attorney because there's a power of attorney in place. It's important that we manage that risk very, very carefully. You probably think that the current Rule 10 doesn't work for you because the accounts that you operate don't provide weekly statements, or that you're not the only one that's involved in transactions, so you can't keep a track of all the transactions and complete ledgers. We've taken that on board, and we issued a notice a few weeks ago confirming that, yeah, if you can't comply with Rule 10, then as a minimum, we expect you to obtain statements when you can, but keep a record of all transactions that you've instigated as the individual or firm. You probably think why, and I think I always mention it because it's a case that sticks in my head, is where an individual solicitor was signatory to a client's own personal bank account and slowly just wiped the account clean. There was no checks that were done because it wasn't deemed to be client money for the purposes of the accounts rules, so it wasn't picked up as part of the annual review that was done by reporting accountants. The first time we became aware of the issue was when there were claims on the compensation fund, and you saw the amount of money that was being taken. So we are trying to manage a risk. It's not saying that we're putting something in just for the sake of it. But like I said, guidance is there, and it's probably useful for those that just need to refresh themselves in terms of what we expect in terms of good records and what it means to have a good record. And I just need to emphasise as well is that, please rely on the SRA's guidance. We've seen a lot of commentary at the moment where third parties that are not linked to the SRA are providing guidance or commentary on what they think the rules should do. And it's probably causing more harm than good. If you are stuck, and I think this is a point that Sean will pick up as well, and Liz at the end, is that, yeah, come and talk to us, please, especially on the grey areas that where you think there are grey areas or you need some advice. We don't endorse any of the commentary that's out there. So if you have got issues, like I said, speak to us today. We'll take questions. But I'm going to pass over to Sean now.
Thanks, Jatinder. Good afternoon, everyone. So my first slide's about putting things right. So probably looking at the slide in reverse order, you need good and effective systems and controls in place to be able to identify when things go wrong. There's a new, the new rules sort of widen the scope of who is responsible for correcting any errors, and they don't have to be errors which have led to the loss of client money. They can be poor systems or controls which could potentially lead to the loss of client money. And it's the people responsible for those corrections are the authorised body, the manager, and the employees. So it's a far broader definition than we've got at the moment. In terms of rectification, we say that should be done promptly. We don't define what promptly is, but I'd say if you find an error, especially if that's meaning client money is at risk or there's a shortage on client account, then that needs to be rectified immediately. It's difficult with systems. I think what's important to do is if you do find breaches, you need to learn examples from them. You need to see what weaknesses there were in the systems and what you can do to rectify those and improve them, make them more robust going forward. And you also be mindful of your obligations to your insurers, which we'll come on to in a minute. So reporting your concerns to us, we've been through a big exercise of our question of trust. We've seen that really people aren't sure what to report to us and when to report that and what mechanism they should go through. The new rule that we have, which comes in on 25th of November, is quite clear about what we expect from you, and we've held lots of workshops on the back of the proposed new rule. That says that reporting to us should be made promptly when you reasonably believe that the conduct is capable of amounting to a serious breach of your regulatory requirements. You should report to us any matter you think or we could reasonably use our powers to investigate. And you should not, under any circumstances, prevent someone from making a report or treat that person detrimentally if they do make that report. So what does that mean? What are our expectations? We say you need to use your judgment in what to report to us and when. We don't say that you can't investigate the matter yourselves, and we do encourage you to conduct your own investigations and deal with matters locally. But we do expect you to engage with us at an early stage so we are aware of any potential issues and we can work with you to try and resolve those. And there will shortly be some case studies issued, which will give some practical examples of the types of things we'd expect to be reported to us. So touched on briefly PII. A breach of the accounts rules is a claim on the indemnity insurance. It doesn't, as I say, it doesn't have to be relating to a loss of client money. Your PII providers need to be confident that you're managing those risks around client money. And obviously, it's a contract of utmost good faith, so you don't want to be in a position where they wouldn't pay out because a risk has been there for a long period of time. And again, repeated breaches, they shouldn't be happening if you've got a good control environment where you're learning from mistakes and correcting systems as you go along. Third-party managed accounts, or TPMAs. So this is something we've allowed firms to do since December 2017. So nearly 2 years now. We've got a new Rule 11 which covers TPMAs. There are a number of companies that are entering in the market to provide these services, and we hope there'll be more to come, given that we've got a specific rule around these now. Worth flagging that any money held in a TPMA is not classified as client money, and you can use a mix and match approach. You could have a normal client account, but you could have a TPMA or various TPMAs running alongside that. And what it does is it potentially allows you to stay under the threshold for requiring an accountant's report. Again, it's another way of reducing the regulatory burden, along with the exemption we've brought in respect of Rule 2.2. And you don't need our permission to use a TPMA, but you do need to tell us that you are using one and who the provider is. And there's again, details on our website of how you can do that, along with some hopefully useful guidance. Just to pick up on some of the main points from the guidance, probably the most important thing is to let your clients know that you'll be using a TPMA so that they can make a fully informed decision in terms of engaging you. It obviously doesn't have the same level of protection in terms of the compensation fund, but it has different protections because any TPMA provider would need to be FCA regulated, and then we'd fall within the Financial Services Compensation Scheme. And another useful bit of advice, if you do go down that route, is to make sure you get regular statements from the TPMA provider. And I'd suggest not just getting the statements, but checking them thoroughly when they do arrive to make sure all those transactions listed are the ones you'd expect to be on there. So the role of the reporting accountant, we recognise how important the role of the reporting accountant is. It's quite often for many firms the only time a third party will come in and have an independent look at the accounts and also the systems and controls that sit behind them. I guess we came into, it was phase 2 of the changes that we made on the accounts rules, where the reporting accountants, where it was changed, and we asked them to look on a more objective basis, a more principled look at the accounts. So we did away with the checklists and the tick box exercises, and they were asked to use their judgment far more. And that's really paid dividends, but there has been an issue where they're checking against quite prescriptive rules up until now. So we're hoping that once the changes come in on the 25th of November, that we will see more alignment between the work of the reporting accountant and the accounts rules themselves. So moving on to the engagement. So we've again stripping out some of the prescription. We no longer prescribe the exact wording of how you engage your accountants. We will, if necessary, if we think there are big risks in particular areas, we may specify that the accountants have to look at certain areas in more detail than others. And the example there around banking facilities. And again, there's some, I think, good guidance on our website, which is not, even though it's called Planning for and Completing an Accountant's Report, it's really useful for compliance officers as well. It sets out what we expect in sort of a traffic light system with really good controls, not so good controls and areas where we think should be really tightened up and moved away. We've also reduced prescription around the final accountant's report. Hopefully this means we don't get a lot of cease-to-hold reports that we don't need. We currently get a lot where firms are just changing their legal status from a partnership to an LLP, for example, which really wasn't the purpose of those reports. So again, that's no longer a mandatory requirement, but we may ask in situations where we feel there is a heightened risk of loss to client money that we do receive a cease-to-hold report. Qualified accountants' reports themselves. So one of the joys of being in the forensic investigation unit is we review every single qualified accountant's report that comes into the SRA and then decide what action to take. The good news is that we receive far fewer reports now since the changes we introduced to the reporting accountants regime. And what we also have seen is that the reports are far more relevant to us. We used to get a lot of what I'd say technical breaches around 17.3, for example, where firms would keep money in client account, office money in client account for longer than the 14 days. We very rarely see those breaches now. And when we get reports now, we're far more likely to act on them than we did previously. So I think that system is working. But again, we do look, with all of those areas where we potentially take action, we do look at what the accountants say in terms of the control environment and how the firm have corrected those breaches or systems failures going forward. And we will assess those reports or any reports you make to us in accordance with our enforcement strategy, which Juliet mentioned earlier today. We've got a range of areas on this slide which we might look at, take into account before we decide what regulatory action we take, if any. I'd probably point to just one of those areas around insight and remediation. Again, we get a lot of reports around issues with residual balances. We realize that firms will unavoidably have residual balances in certain circumstances. If a firm has got a relatively small number that haven't been there too long and that they've got a good plan of how to deal with them, then it's unlikely we do anything with them. But contrast that with a firm who might have had 3 or 4 qualified reports about the same issue. Those balances haven't even been quantified by the firm, and they've got no real desire to address the issues going forward, then that's far more likely that we will take regulatory action in those circumstances. And a variation on another slide you would have seen this morning, not far away from the implementation date. In terms of the accounts rules, what you need to be thinking about is that shift away from the prescriptive nature of the rules. The focus that we now have on systems and controls and how important it is for those to be adequate for you and for your firm. So you're not looking at off-the-shelf packages. It's got to be specific to you and what you do. Have all staff involved in that because of those reporting requirements that they will have. Please do visit our website and the beta site that's up and running at the moment and see all the guidance that we've got on there. Use your reporting accountants. You will pay a lot of money to them, no doubt, each year, and they will make recommendations to you in the management letter about systems and controls. So please make sure you are actioning those recommendations. And finally, and hopefully it's good to see so many people here today, you will do this, is talk to us. We're not as bad as people make out, so we will try and help you out wherever we can.
Thank you very much, Sean and Jatinder. Thanks. So we've got a good 20 minutes or so for questions. So I can see there's 1, 2, 3, 4 fixed mics. For those of you who are feeling a bit brave and energetic, would like to go up to the fixed mics, or we've got some paddles around as well if you'd prefer to raise your hand. Any questions? There's one just down here, thanks. Can you say where you're from and your name, please, before your question?
My name
Thanks.
is Miss Ogbonna. I'm from Rose Bonner Solicitors. I don't hold client account, but I've been on some recent training conferences where we've been introduced to some third-party holders, custodian holders of funds. And I want to know exactly the SRA's approach to that. Would there still have to be accountants' reports in respect of the monies held by such organisations?
No. So one of the beauties of having money in a TPMA is that it's not classified as client money, so you don't need the same level of controls around that. You don't need to, have the same level of scrutiny about those balances. If that's the only money you hold, and you don't have a client account generally, it means that you don't have to have an accountant's report at the end of the year. So it's far less requirements around that, but the safeguards are then built in around the dual signatories and FCA regulation and things like that.
So would there need to be any reports to the SRA? Would there need...
Only in terms of telling us that you are using a third-party managed account and who the provider is. And we've got the forms on our website as to what you need to do with those.
Okay, thanks very much.
Okay. Yeah, question there, thank you.
Jane Willets, I'm a regulatory solicitor based in Birmingham. Could I just ask you about agreed fees? This is a question that's been coming up quite regularly. Rule 17.5 obviously is abolished now, but firms are asking whether they can use agreed fees, whether there's a solution. I have heard from some that a solution may be to raise an invoice on office account before the agreed fee is paid, but obviously you run into the issue of whether or not you're allowed to invoice an anticipated service, which I'm not an accountant, obviously, but I think that's an accounting rule that you're not permitted to. So I'd be interested to the SRA view on that.
So I think that's something that we've been asked quite a lot of recently, and probably hasn't been helped by the commentary, like I said, that has been out there, that hasn't been confirmed by us. So people are trying to fill in the gaps in terms of what they think law firms can and can't do. The concept of agreed fees has been removed. And like I mentioned, the reason was partly because of the fact that people get confused between agreed fees and fixed fees and what can be done in terms of moving it into an office account immediately. What we're saying now is that the way that the rule works in Rule 4.3 is that, you can, if you're looking to bill for your costs as a firm, that you can bill the client and then take those costs from the client account if they have been received on account into the business account. And then if you're looking at disbursements which are yet unpaid because it's still client money, but once they're incurred, i.e. that the third party has contacted you to say that the services have now been provided to the client or for the client, then you would rely on the second part, which is that or written notification of costs incurred. We've got to think about that even though there's some flexibility for law firms, it was the risk to clients as well, that what the rules are there to do is to make sure that client money is kept safe. So in the agreed fee scenario, again, it was looking at what is the risk there to clients in the sense that if something did go wrong, even though they understand the terms in which that they're actually passing that money over, that even though the matter doesn't complete, the firm can still take that money as theirs. Is that really where we want to be going forward? So I think law firms really need to just understand now that if they were using the agreed fee model, they might need to just adjust their practices. And as you said, that it might be that they then have to raise a bill in accordance with Rule 4.3 in terms of their costs. So it's the profit costs of the firm. And then in terms of disbursements, they wait until those have actually been incurred and invoiced at the very end, or provide a notification of costs as they go through. I think it's probably been confused slightly as well by the recent Court of Appeal decisions that came through from the Slade case, where it was about at what point that if a firm is using interim billing or that sort of approach, that when can you then challenge, as a client, when can you then challenge the firm in terms of the reasonableness of those bills? that is it when the interim bill has been delivered, or is it at the very end when a final statement of accounts has been delivered to the law firm? And I think Sean and I have heard that more than once today and in other forums, so it's probably that we will have to think about providing some sort of guidance to provide clarity. But I think from those that are sitting here today and in this morning's session, we did say, please talk to us. Like I said, there is too much commentary there at the moment, which is probably causing more harm than good and making firms more confused than they need to be, that they should be talking to us and our ethics team or Sean and myself.
Okay, another question just down here, thanks.
So just for clarification, to pass costs straight into office account rather than via client account, if it's fees and disbursements incurred, just to clarify on what you've just said, that means it's not disbursements which are anticipated to be incurred. You actually would have to have a contractual liability at the time when you take the money from the client, because it's just equally possible that you could send a notification to the client of a fee that you've agreed, and at the same time for a disbursement which you know what the cost is going to be, but you haven't actually incurred the cost. So it's a problem over the word incurred.
Yeah, I think it is that maybe, well, I'm not sure whether it's a problem or it's just around interpretation. And I think what we've got to think about here is, or law firms have to think about things like the VAT implications as well. That if they do move something into their business account for stuff that hasn't yet been incurred, or even for services that haven't been provided, where does it leave them in terms of VAT implications? So I think it is something that we will have to look at in terms of making sure that we provide some clarity in terms of what it means for firms. Because as you say, even though it's incurred, technically it's still unpaid under the definition of client money. So where does it sit in terms of client account or the firm's business account?
Okay, I was just looking to see if I missed anyone at the back. Shall we do those two? Yeah, do those two there along from number one. Thank you. So there's one and then one further along. Thanks. And then one there. Yep.
Did you need to say what number?
Hi,
Yeah.
Shabul Haq, Westgate Solicitors, London. You mentioned that mixed money should be moved to the correct account promptly. The term promptly being relative, would you please shed some light on as to any guidance as to how long promptly is, please?
Well, we'd have to look at individual circumstances. So at the moment, it's the 48-hour rule, isn't it? Really, we'd say as soon as you realise it's not in the right places, you need to move it. But it will depend on individual firms and the volume of transactions that are going through. If you can't make electronic transfers, you might have to go to the bank to make transfers, and that would take a bit longer. So it would depend on individual circumstances, but promptly is never going to be 3 or 4 weeks or a month or whenever. It needs to be on those individual circumstances.
And I think just to reinforce what we were saying before as well, that firms really need to look at the accounts rules together with the obligations that sit in the Code of Conduct for firms. That if your firm's money is sitting in the client account for an unnecessary period of time, there is a concern then that your firm isn't financially viable, or that you're avoiding either your obligations in law, whether it's through the insolvency route or anywhere else. So it's important that law firms do look at the effectiveness of managing their business, and that includes their business accounts as well, that money does need to be moved across promptly so that you aren't subject to whether it's insolvency proceedings or any other creditor knocking on your door. And as Sean said, I think it's the same in the other side, that you wouldn't want client money sitting in your business account unnecessarily, or should we say for an unnecessary long period of time, because if something should go wrong in the firm, that client is then not protected because that money would be eaten up. Whereas at the moment, or if the money was in the law firm's client account, at least there is some protection for the client.
Okay. We'll take that one with number 2 and then back to the other one in the middle at the top. Thanks.
We attended a Nottingham Law Society seminar on the accounts rules, and we now are having difficulties with the advice we got there. We run trust accounts where the firm has trustees, and we open up separate bank accounts in the trustees' names, so we do not provide banking facilities. The bank is now saying, or our bank is saying, it will not operate those sort of accounts anymore, and it is claiming that we can use client-designated accounts for these trust monies and keep them separate that way. Would that still be providing banking facilities?
I think what we've done to help law firms in those situations is look at the case studies that we published alongside the warning notice in August last year. And I think it's imperative to understand that if the trust or the trustee that's been appointed is providing some sort of professional services to the trust and its beneficiaries, then we wouldn't see that as a banking facility. But if it's just the case that the money's just being held and there are no services being provided through the appointment of the trustee, then that would potentially fall within breach of a 14.5 issue or 3.3 going forward. There is, like I said, the case study that sits on the website with the warning notice in terms of what we would expect law firms to do where they are appointed as trust or dealing with trust administration work as well. I appreciate the risk, and I think this is where banks are becoming more reluctant to provide those sort of facilities. And under the new definition of client money, it does say that it does include trust money as well that's been received by the firm. So it's looking at what the options there for you, but it's making sure then that the holding of money in your law firm's client account relates to the professional services that you're providing as trustee.
So that doesn't answer my question, with all due respect. We can't open now with our bank a separate account to put trust monies in. They're saying put it in a client-designated account. These trust monies, on some occasions, they are just paying money out regularly to beneficiaries of the trust by direct debit, or they're paying direct debits to utility companies on their behalf. If we have the money in a client-designated account and we set up direct debits, we understand we can have checkbooks and direct debits on those accounts. Will we be providing a banking facility, or will we not?
I think now you've clarified what the facility will be used for, i.e. to pay utility bills and other things that have got nothing to do with the provision of legal services or regulated services, then I'd say yes, you would be foul of 14.5.
Right, thank you.
Okay. Is there still one at the back? Or I think that's, yeah, that one there maybe.
Hi, Ishmael Malik from AMJ Legal. I have a question about some convincing transactions where funds are held for more than 6 months and instructions are not matured. What sort of obligations do we have in those circumstances?
Sorry, can you repeat the question there?
In one of my convincing transactions, the instructions are not matured, but I'm holding funds on account for more than 6 months. So please guide me, what sort of obligations do we have?
So that money is still related to your regulated activities, which I presume it is. And then there are you anticipate that those transactions that money will be required to complete your regulated services, then that is okay to hold that money in client account. It's not a breach of the 14.5 and the new 3.3. But you do need to keep your clients informed, I'd say, of the money that you're holding and account to them on a regular basis for that money.
Okay. Yeah, just in front of the paddle 4 there, just in front. That's right. Thank you.
Hi, Lake Birdie from Birdie and Company. Sorry about that. I was just to wake everyone up. My question is about third-party managed accounts. I'm very unclear on that. It seems to me that the funds are doing the same thing as a bank. As I understand it, whatever money is received, it goes into the account. You give it to a third party, they place it into an account. So how would that, and we're still required to do monthly reconciliation. We're not?
No, under the rules, there's not that requirement. The thing about third-party managed accounts is that it won't be just you and your firm that's in control of that money. There are other people who may be joint signatories on that account. So the additional safeguards come in from those extra controls. And that's why we don't classify it as client money, because there are these other safeguards in place. So it's quite different really to a normal client account. It's barristers, for example, use third-party managed accounts. They can't hold client money, so any money that they hold comes into a third-party managed account, and it needs 2 signatories, for example, before it can leave that account and be paid in their costs or whatever.
I think just to add to that, just have a look at our guidance as well. What we've said is that there might be circumstances where the client is a joint, should we say, mandatory signatory to the movement of money, but what the client has when you've got a TPMA is the right to refuse the movement, or should we say not authorise the movement of any money if they've got any concerns. This is giving the client control in terms of how the transaction's managed rather than relying on the law firm to move money as and when they think it's necessary to do that.
Okay. Number 3 or 1 at the back. Could you get the lady in? Yeah, I don't know. One of you get that lady whose hand's been up a few times. Thank you.
Hi, Jo Creamer from Pinsent Masons. I've just got a question about the final cease to hold accountants reports. I understand that obviously it seems like it'll be on a case-by-case basis per firm. We do a lot of advice for firms that perhaps are going into administration or are just having a managed wind down. So again, to ask that question about do they need to do a cease to hold, would it be again like every time we advise them, for example, would we need to come to the SRA to ask that question? And if so, who do we go to?
Yes, it would. So it's our authorisation teams who will make that call, and they'll ask you. So you obviously put in some sort of report to say that the firm's closing, and then the authorisation unit will say whether or not they require a cease to hold in the circumstances, and they'd look at then the risk factors that we'd have in those circumstances.
Okay, thank you.
Okay, can we take the one in the front row, please? And then we'll take maybe the one behind. I'm conscious we've got a few more minutes. Thank you. Number 2, thanks.
Thank you. Ian Woods, Elliott Mather, East Midlands. We're a growing law firm, and we have a large residential conveyancing department, and we're seeing increasing numbers of referral fees. How do the SRA see referral fees going forward? Do you see it as an area that needs more regulation as part of residential conveyancing departments, or is it something that we can allow to develop with our local agents and contacts?
It's not an accounts rule specific question, but I suppose being the SRA's lead on referral fees, I can answer it. And so referral fees have always been a cause for concern for the regulator, in the sense that I think I said this morning to someone that when I got seconded into, there was a referral fee project in 2007. The then chair said to me, Jatinder, just one thing to remember, clients are not to be sold as a commodity. And I think that's stayed with me since, in the sense that when I go out to talk to firms and they're looking at their referral arrangements, I say that, okay, there's nothing wrong with you having an arrangement for clients to be referred to you, but we've already seen some interjection from government already in terms of where it's personal injury, so fees are banned there. In terms of conveyancing, there's a department that keeps on changing its name. It's a government department. They carried out some research in December last year, and one of the questions that they asked in their research or call for evidence was that should referral fees be banned in conveyancing? I think prior to 2004 they were banned through our rules, and then the ban got lifted and then got put back in and then taken out again. So at the moment there's no ban on referral fees in conveyancing. But whether government now step in and say that it's not appropriate for referral fees in conveyancing, that's something that we'll have to wait and see.
Thank you.
Probably got time for one more one if it's a quick one. Could we go for the lady in the 3rd row who had her hand up a while? Thank you. On number 4, thanks.
Hi, I had a question about Rule 10, or the new Rule 10, in terms of acting as a signatory on a client's account. We have quite a few Court of Protection accounts that we've got online banking access to, so we can make payments up to a certain amount on them. But we're not actually signatories on a banking mandate. You know, we can sign off on checks or go into the bank and do any kind of transaction. It is just online banking access. Does that count as acting as a signatory in your view?
Yeah, so what the rule says is where you operate the client's own account. So it doesn't matter how you do it. You can do it through digital online banking, or you could be the signatory on a checkbook, or you could have the client's own debit or credit card. So the rule is quite, should we say, broad in that sense, that it encompasses all accounts that you operate on behalf of the client. So that would be core. But like I said, that we appreciate that you're not the only person making transactions in those circumstances. So the notice has been issued to provide some flexibility, but it is, like I said, something that Sean and I would need to go back and look on, probably in the new year now, just to sort of think about, okay, we need to manage the risk, but how we do that might not be where we are in terms of the current Rule 10.
Thanks.
Okay, I think we're going to have to stop there. I'm really sorry. I know there's some more questions, and Sean and Jatinder actually took about 40 minutes after the session this morning answering individual questions, but unfortunately we've got other people coming in for the closing session here. So in terms of where to look, you can take a look at our guidance and do look at the beta site. I think you can probably track them down via the conference app, I think. Is that right? And also in terms of email addresses, it's just jatinderpal.loyal and sean.hankin@sra.org.uk. And don't forget the professional ethics helpline as well, so that hopefully you will be able to get your questions answered. And sorry we couldn't do them all today. But in the meantime, if you can just thank Jatinder and Sean for everything. And if you can stay here, because the next session, I think there's everyone will be transitioning in. So if you can stay put, that would be really helpful. Great. Thanks very much.